What's the best way to determine the amount of consulting or management fees to structure in setting up a multiple entity structure for a law firm? This law firm is an elder law firm, and they spend a considerable amount in client benefits, such as flowers for the deceased, funeral expenses, gift sets, etc. The CEO is not a lawyer and therefore can't be a partner in New Jersey, although she really should be a partner. I got you on that one, Vanessa. Considering setting up a second entity with the CEO as 100% owner and paying out a year-end fee, half of the profits of the year. So let me go through this again, and I'm going to look at your second post. What's the best way to determine the amount of consulting or management fees to structure and setting up a multiple entity structure for a law firm? Okay, I get this. So what I think you're going for, and then I'm going to read your second comment, is that we have a law firm, and in that law firm we have a CEO who can't be partnered because the CEO is not an attorney. And so we want some consulting or management fees to be able to go to that CEO. So second entity business purpose. Here we go. That's what I wanted to know. Talent development or employee leasing for the law firm or for client care. Got that. So with the CEO, so that's the second entity's business purpose, and the law firm would be paying a fee to that second entity. And okay, so one of the ways that you can go about doing this, if the law firm is going to pay a management fee or consulting fee to the second entity, and that second entity is going to pay for talent development or employee leasing, a typical place to start is however much it's going to cost that second firm to do its operations. And I don't mean CEO salary. I mean, whatever it's going to cost them in products and services, that's what the law firm pays as a management fee or a consulting fee. Then step two is, on top of that, what are we going to add to that if we want the CEO to get some compensation from that second entity, assuming that the CEO is going to be involved in that second entity? Oh, thanks, Vanessa. Okay, yep. Now, I don't know if we're talking about a C Corp or S Corp or LLC, or I don't know that part of the fact pattern yet, but keep an eye out for any tax implications or any form over substance implications, because what you don't want to do is set up a structure that looks like a sham, but even if it's not in reality. You don't want to set up a structure that looks like one. You don't want to set up something that looks like income shifting, even if it's not. IRS is big on the substance over form. So are they both S Corps, Vanessa? They're big on substance over form. And here's the risk. If it's an S Corp, is the CEO I get not a partner in the law firm, but can a CEO of a law firm be an S Corp owner, but not a partner in the law firm? I don't know the answer to that, but I'm going to share a concept here. Maybe it'll apply to this situation or to other situations. The S Corp has a special consideration for compensation if an S Corp is an owner, and that is that the idea of reasonable compensation. Now, you, Vanessa, probably know about this, but since a lot of people are going to watch this both live and after the fact, I'm going to share this. Reasonable compensation says that if before someone in an S Corp, an owner of an S Corp, can take distributions, which have a little bit of a tax advantage, they first have to get paid as a W-2 employee, reasonable compensation. So distributions are like the pot of gold, right? Everybody wants distributions because of the tax advantage, but you have to get sludged through the mud. Okay, I have to get my reasonable compensation first. If that's the case, if the CEO is also an owner of the S Corp, then if that's the case, by splitting up the CEO's compensation, you're staying deeper in that mud of reasonable compensation, and you're keeping that CEO away from that tax advantage of those distributions. So what you might want, if this is the case, again, that key question is, I don't know if owning an S Corp that a law firm is the same as being a partner for purposes of the New Jersey State Bar. Get clear on that. But if that's the case, I would keep the CEO's compensation in one of these companies and not the other in order to get past that reasonable compensation threshold and get up to distributions as quickly as possible. But make sure that that second entity is really providing value. It's not just to shift over, like to start over the workers' comp clock, or, if there have been issues in the past, or, make sure that there's a substantive reason for having those services in a separate entity. Maybe it's for purposes of insurance, right? I mean, the law firm's doing one thing and is insured in a particular way. The second entity, design that very deliberately, not only for compensation, but to make sure that even to the IRS, it would look like a substantial second company. And I think you're on the right track here. Just be aware of the point of reasonable compensation. You don't want to split it up if you don't have to.